The dispute concerns allegations coming from the claimants, saying that the respondent has breached the BIT in their treaty when it decided to apply several tobacco control measures regulating the tobacco industry. Amongst the measures that the respondent's government adopted, there is a single presentation requirement precluding tobacco manufacturers from marketing more than one variant of cigarette per brand family, hereinafter called the single presentation requirement. It also increased the number of graphic health warnings appearing on cigarette packages, hereinafter called the challenged measures. The single presentation requirement was implemented through the Ordinance 514 on August the 18th of 2008 of the Uruguayan Ministry of Public Health. Its Article 3 requires that each cigarette brand has a single presentation, prohibiting different packaging or variants for cigarettes sold under a given brand. Until the enactment of the ordinance, ABAL HERMANOS had sold multiple product varieties under each of its brands, for example, Marlboro Red, Marlboro Gold, Marlboro Green, and others. As a result of Ordinance 514, ABAL HERMANOS stopped selling all but one of the product variants of each brand that holds license to, Marlboro Red. The claimants alleged that these measures and the lack of variant sales has impacted negatively in the value of the company. The challenged measures, or the 8080 regulation, was implemented through the enactment of the Presidential Decree No. 287 from June 2009. This decree imposes an increase in the size of the prescribed health warnings of the store face of the front and back of the cigarette packages from 50 to 80%, leaving only 20% of the cigarette pack for trademarks, logos, and other information. The claimants allege that this limits negatively the ABAL HERMANOS right to use its legally protected trademarks and prevents them from displaying them in the right way. According to the claimants, this measure caused a deprivation of the Philip Morris products and ABAL HERMANOS intellectual property rights and further reducing the value of the investment. The challenged measures, according to the claimants, constitute breaches of the respondents' obligations under the BIT Articles 3.1, Impairment of Use and Enjoyment of Investments, Article 3.2, Fair and Equitable Treatment and Denial of Justice, Article 5, Expropriation, and Article 11, Observance of Commitments, in this way entitling the claimants to compensation under the treaty and international law. In response to the claimants' allegations, the Republic of Uruguay, as a respondent, holds that the challenged measures were adopted in compliance with Uruguay's international obligations, including the BIT, for the single purpose of protecting public health. According to Uruguay, both regulations were applied in a non-discriminatory manner to all tobacco companies, and they amounted to a reasonable good faith exercise of Uruguay's sovereign prerogatives. The single presentation requirement was adopted to mitigate the ongoing adverse effects of tobacco promotion, including the claimant's false marketing that certain brand variants are safer than others, even after misleading descriptors such as light, mild, ultralight were banned. The 8080 regulation, on the other hand, was adopted to increase consumer awareness of the health risks of tobacco consumption and to encourage people, including younger people, to quit or not to take up smoking, while still leaving room on packages for brand names and logos. Thus, for the respondent, this case is about protection of public health, not interference with foreign investment.
Now let's just turn to the applicable rules and analysis of the case. Here, the tribunal has been tasked with determining whether the respondent has breached its obligations under the bilateral international treaty. As it is known, the governing law in this case is the BIT. That's why we have to take a look of the importance of Uruguayan law as a way for establishing the rights the state recognizes as belonging to the claimants. The legality of a modification or cancellation of rights under Uruguayan legal framework, it doesn't have to determine whether such an act may constitute a violation of a BIT obligation. When a violation has in fact occurred, has to be decided on the basis of the BIT itself and other applicable rules of international law, taking into account every pertinent element, including the rules of Uruguayan law applicable to both parties, as Article 42 of the ICSID mentioned.
Moving forward to the considerations of the court, we pass to the first segment, that is expropriation. In this case, the claimants that are Philip and Morris think that they were expropriated, that their investment were expropriated in violation of the Article 5, numeral 1st of the Bilateral International Treaty. Uruguay expropriated the claimants' brand assets, including the intellectual property and goodwill associated with each of claimants' brand variants. About the legal standard, the tribunal analyzes that ABAL remained registered owner of licensee of the relevant trade markets and continued to be entitled to protect them by an action of infringement. Article 5 of the bilateral international treaty refers to any measure having the same nature or the same effect as an expropriation or a nationalization. Thus, indirect expropriation under the treaty is defined in a different and apparently stricter way than in other treaties that make reference to measures, the effect of which would be equivalent to a nationalization or expropriation. Taking this concept into account, the indirect expropriation was denied by the tribunal for two main reasons. First, because the measures did not have a significant effect in order to damage the claimant's investment value, because the partial loss of utility is not accorded as an expropriation, it has to be total. In addition, the regulations were a valid right from the state in order to protect a commonwealth.
Moreover, one of the articles cited by the tribunal was Article 11 of the BIT, under the rubric Observance of Commitments, where one of the questions was whether a trademark falls between the two categories, like be considered a commitment under general legislation or, by reason of the individual consideration, involved in the initial grant as a specific commitment to a specific investment or investor. What happens here was that claimants argued that it is a commitment that arises when a submitted registration application is granted under Uruguayan law to an individual person or entity, but Uruguay entered into no commitment with respect to the investment by granting a trademark. That means it did not actually agree to be bound by any obligation or cost of conduct. It simply allowed the investor to access the same domestic international public system available to anyone eligible to register a trademark. Trademark, it is not a promise by the host state to perform an obligation. It is simply a part of its general intellectual property law framework. A trademark gives rise to the rights, but jurisdiction, being subject to the applicable law, is liable to change which may not be excluded by an umbrella clause. If investors want stabilization, they have to contract for it. The tribunal concludes that trademarks are not commitments.
The Uruguayan's position, the respondent, that in this case is Uruguay, argues that the TCA and the Supreme Court of Justice are co-equal institutions with different spheres of competence. The TCA rules on administrative acts, the Supreme Court determines the constitutionality of laws. Thus, according to Uruguay, the existence of allegedly different decisions is not sufficient to amount to a denial of justice. The relationship between parallel administrative and constitutional system is critical in determining whether justice was denied. Uruguay also argues that the existence of divergent jurisdiction is not sufficient to amount to a denial of justice. These arguments are the ones that are going to consider the tribunal and deny the denial of justice, since these contradictions between the courts are not a proof or a proof of a failure of the system as a whole.
The tribunal notes that this case has given rise to important and complex legal issues, and that both the claimants and the respondent have raised weighty arguments in support of their respective positions. The tribunal finds that, in the circumstances of this particular arbitration, the application of the loser pays principle is appropriate. It does not consider that either party's procedural conduct in the arbitration has been such that it should be taken into account in apportioning costs. Even so, the tribunal notes that all jurisdictional objections raised by the respondent have been rejected, but that the claimant's different claims of breach of the BIT have been substantially rejected. On balance, the outcome of the case has favored the respondent. The outcome of the case and the significant disproportion between the parties' respective costs, the tribunal decides as follows: A. The claimant's claims are dismissed, and B. The claimant shall pay to the respondent an amount of $7 million on account of its own costs, and shall be responsible for all the fees and expenses of the tribunal and exceeds administrative, fees and expenses, reimbursing to the respondent all the amounts paid by it to the center on that account.